there is discrimination, they have to raise the pay.
Notwithstanding the union contract, correct?
If there, yes,
Okay.
correct.
Now, as you know, the Federal Fair Labor Relations Board makes it an unfair labor practice for an employer to pay employees more than called for under union contract, because that's one of the ways an employer can try to break a union is by paying more than the union negotiated to prove to the employees that they don't need a union. So doesn't this law require an employer to violate the Federal Fair Labor Standard Act, the Federal Relations Employee Board regulations, by increasing a pay above that amount negotiated?
That employer is always and will still remain, you know, within complying with the Fair Pay Act. So that employer is still, that employer cannot discriminate, period.
But federal law preempts state law, correct?
Yes, the court will determine those remedies.
But federal law preempts
and if that
state.
negotiated contract is based on discrimination, discrimination is not going to be tolerated, period.
And federal law preempts state law.
They
So
can
if federal law
renegotiate that
prohibits an employer
provision.
from raising it above the amount negotiated. Don't we have an inherent conflict in this legislation?
No, we do not. They can always renegotiate that contract.
Now, if a union takes a particular position and negotiates an unusually high salary for that one position, can the union then turn around after the contract's been signed, file a complaint, and tell the Labor Department they should raise all the rest of them?
No.
What prevents the union from doing that?
Why would the employer bring a complaint against themselves?
No. A union negotiates an unusually high salary for one labor class. They sign the contract. Then the union turns around, files a complaint, pointing out that another class of employees is not being paid as much and should be raised. Is there anything in your bill that prohibits that type of activity?
Again, yes.
What section is that?
What section is that? Line 38, page 3 of the bill.
So you're saying if the union set up the employer, the union would be violating the law?
That was your scenario. Yes.
And then what is the sanction against the union? Is the union fined?
No, that contract would just be no.
Does the union pay any higher wages?
Are you asking for the court's remedies?
Yeah, what's the remedy against the union that violates that section of the law? Is there any fine against them? Are they required to make up the pay differential? Do they pay the attorney's fees? Do they pay expert witness fees? What is the sanction against the union?
Right. The original remedies will still exist, not penalties against the union, if that's what you're alluding to.
Okay, that was my read, too. I didn't think there was any penalty if the union violated this. All the penalties seem to apply only to the employer.
Right.
Now, this bill would apply both to private employers as well as public employers, right?
Correct.
And under this bill, if the Labor Department found there was made this determination that there was a wage disparity, the Labor Department could bring the lawsuit on behalf of the employees, correct?
Correct.
And who would represent the Labor Department? Would they be represented by the Attorney General's office?
Most likely, yes.
And if they sued the state of New York, would the state of New York also be represented by the New York State Attorney General?
Who's suing the state of New York? They would have to then, in that scenario, bring an independent counsel.
So we would have taxpayers paying for lawyers to sue the state, and we'd have taxpayers then paying the lawyers to defend the state. I can see how this is great for lawyers. How is it great for taxpayers?
Right. But then again, you also have to step back and remember that DOL is not required to bring such a lawsuit. They can remedy it with a voluntary resolution, of course.
I'm a little concerned about the whole concept of state taxpayers paying for lawyers to bring a lawsuit against a private employer in order to get money paid to a private citizen. Doesn't that process violate Article 7, Section 8 of the New York State Constitution?
No, it does not.
Why not?
I mean, what you're I guess, describing, of course, to right any wrong, unfortunately, you will encounter various obstacles, but I think that we need to be continually committed to addressing the wage disparities that we have in our state.
Well, if an employee brings a lawsuit against the employer, can the employee, and the Labor Department doesn't agree, will the Labor Department defend the employer?
No.
And if an employee brings a lawsuit against the employer and wins, this bill says the employee gets their lawyer fees paid for, correct?
They can, yes.
But if the employer wins, and let's say the court throws it out, says it's frivolous, if the employer wins, do they get their costs reimbursed?
The CPLR does afford that.
Only in a narrow circumstance where it's frivolous. And if it's not frivolous, they don't get any reimbursement?
Say it again. But that's what you just said.
Okay. Now, I see this also says that if an employee wins, the witness fees can be paid, reimbursed to the employee, correct?
Yes.
But if an employer wins, they don't get any reimbursement?
Is it afforded under CPLR? Yeah, I'm not 100% sure.
Now, this applies to any employer with more than 4 employees, correct?
Yes, correct.
So we're talking about a small business. And a small business could be sued. They may have to defend it at their own expense against state taxpayer-paid lawyers.
But Mr. Goodell,
And if they
litigation
lose,
is
the
not
business,
the only
I'll
remedy.
ask the question in just a minute, Ms. Titus, if you don't mind. If they lose, they have to pay legal fees, they have to pay witness fees. The litigation could be extraordinarily expensive. The cost of the litigation could actually exceed the cost of the amount in dispute, correct? I mean, there's no limit on these other expenses.
Right, discrimination could be expensive. Yes, correct.
Now, I note that in Section 198 of the labor law, where we allow the Department of Labor to bring a lawsuit on behalf of employees where their wage standards are not being met, there are certain protections for the employer, like a statute of limitations. There's a 6-year statute of limitations. Is there a statute of limitations in this bill?
Not explicit. Please spell that.
So an employee could work for an employer for 20 years, retire, and bring a lawsuit knowing that that lawsuit could result in damages that actually puts the company out of business? Because there's no limit on how far back they can go?
Yeah. I'm being told by counsel it's whatever is in the CPLR, which is probably limited to 3 years.
3 years applies to torts. 6 years applies to contract. But there's no express statute of limitation in this.
No. Not
I
in
note
the
that
bill.
Section 198 of the labor law also limits the amount of liquidated damages. Is there any limit in this bill on the amount
No.
that has to be paid for under punitive damages? No limit?
No.
No limit on the amount of legal fees?
No, there is not.
No limit on the amount of witness fees?
No, there is not. Discrimination can be very expensive.
In fact, it could put employers out of business, correct?
That's why you shouldn't do it.
Now, in addition to these requirements, this bill imposes a number of reports that employers have to prepare and submit every year, correct?
No. No.
Oh, employers are not required to keep track of the wages that they're paid and the methodology they use to come up with it?
Right. I mean, under current law, they have to keep payroll records.
Well,
This
I'm a
doesn't
small
impose
business
any other
employer. I
additional
don't report
report.
that information now, but I would be required to under this bill.
Yeah, it doesn't require any additional reporting,
None?
none.
Sorry, I thought I saw that in there, but unfortunately, it's not one of those things that I tabbed. Ms. Titus,
Yes,
I see that great sigh of relief that we've run out of time. Thank you so much for your comments.
thank you, Mr. Goodell.
Read the last section.
This act shall take effect on the 120th day.
Clerk will record the vote. Ms. Glick to explain her vote.
Thank you, Mr. Speaker. I had hoped to have the opportunity, but a committee meeting was called to discuss the bill on the bill. But let me just say that I want to thank the sponsor. The bill is very important. It's based on the historical patterns in which women's work has not been valued, and it is important for us to redress that. And you have to start at the very basis where there are biases that essentially target women into certain jobs and men into others that pay more. Now, I think as time has progressed, we've made some progress, but comparisons of vastly different job categories only obscures the fact that there are many women who are working in very similar jobs that are simply characterized differently in order to provide a discriminatory reason for them to be paid less. So I applaud the sponsor and withdraw my request and vote in the affirmative.
Ms. Glick in the affirmative. Are there any other votes? Announce the results.
Ayes 84, noes 37.
The bill is passed.
Assembly 437A, calendar number 32, Ms. Rosenthal, an act to amend the civil service law.
An explanation is requested, Ms. Rosenthal.
This bill would ensure a fair and non-biased wage structure for all employees in the state and local civil service, regardless of sex, race, or national origin.
Ms. Corwin,
Thank you, Mr. Speaker. Would the sponsor yield?
will you yield, Ms. Rosenthal?
Yes.
Sponsor yields.
Thank you, Linda. Yes, we've seen this bill a few times in the past, but this year there are some significant changes to it, so I thought we might just talk a little bit about the amendments to it. First of all, I see that in the past it applied only to state operations. Now this would include municipalities as well, local governments.
Yes, this bill is a combination of two bills. One bill that I carried for a while was state. Another bill that was carried by Assemblymember Jaffe was local, so they're combined into this one bill.
Okay, great. Thank you. I also see that we changed some of the language here. In some areas we talked about wages. Now we're referring to it as compensation.
Okay, it was changed to make it more appropriate for civil service employees.
Okay, so my understanding, I didn't see a definition of compensation in the bill. How would you define compensation?
Well, compensation is the salary plus certain other benefits, retirement, vacation, sick pay, and any other form of remuneration paid to employees.
Okay, so you're taking it as collectively. So that's a much larger number than just wages. Wages would just be what you're getting paid. I see, okay. I also see that in your bill, because we're dealing with state as well as municipal employers, that your bill requires that a report be done. Let's see, it's every 5 years. Right. A report to the governor and the legislature containing a list of the segregated titles. And by segregated titles, we're talking about the various jobs that have been analyzed and determined to be equivalent with each other, correct?
Yes.
Okay. Now, I understand here as well in the bill, it says that similar report would be done at the local levels.
Yes.
My question to you is, what happens if the conclusions at the local levels are different than what's done at the state level? So, for example, if truck drivers and secretaries are considered equivalent, in a certain town, but not at the state level.
The towns pertain to just that town's jobs. So they're not going to be compared to a job in another town or a state-level job?
Well, wouldn't it possibly happen, though, if that truck drivers and secretaries are deemed equivalent in a town but not at the state, that a state employee may file a complaint saying, well, they're equivalent in a particular subdivision of the state, so it should apply to me as well?
Can you just repeat the last sentence?
Sure, not a problem. So if we have a state-level list of jobs being created, and then we've got local
Right.
lists being created, if they aren't exactly the same, then an employee at one level could file a complaint saying, well, I'm equivalent, I'm not equivalent at my level, however, those jobs are equivalent at a different level.